A governmental subpoena is a legal minefield. It is not to be taken lightly. It is not simply a matter of making copies and delivering them to the government. It is fraught with legal danger. Hello, my name is Daniel Giaquinto. I am an attorney with the law firm of Frier Levitt, and I'm here today to talk about how to respond to government subpoenas for documents. Now, what is a subpoena? A subpoena could be a subpoena for testimony, or it could be what we call a subpoena ducis tecum, that is a subpoena for records. Those records could be hard copy records, they could be digital records. Those records are records that are under your control, possession, ownership, records you have access to. They are requests for what comes under the heading of business records. Very, very broad. Could be patient medical records, could be medical tests, could be billing records, it could be marketing efforts, it could be communications, text messages, emails, letters, basically anything that comes under the heading of business records for your practice or pharmacy. That subpoena can go after. Subpoenas are usually, for records, are usually very broad. They only have to be based on whether they are for a lawful purpose. That is there a lawful government investigation? Are they reasonably related to the government investigation? And are they or are they not onerous to the practice? That's basically the standard. Does not have to be based on probable cause. Does not have to be based on clear and convincing evidence or proof beyond a reasonable doubt. Just whether it's reasonably related to the government purpose or investigation. So as you can see, they can be very broad. There are different types of subpoenas. As I said before, we're going to concentrate today on subpoenas issued by the government during investigations. But there are also subpoenas issued during litigation. For example, a lawsuit, two parties involved in a lawsuit may subpoena doctor records. We're not talking about that type of subpoena today. Nor are we talking about a court-ordered subpoena, which can also happen. Instead, we're talking about the government subpoena that's issued during an investigation, either at the federal level or the state level. It could be criminal, it could be civil, it could be administrative in nature, and all these subpoenas are somewhat different, but they all also have similarities. And it's those similarities and how you should react that we're going to talk about today. Now, I said a little bit about government investigations, government subpoenas. There are grand jury subpoenas, which means the case is criminal. There are HIPAA subpoenas and OIG subpoenas, which are administrative in nature and could mean that there are parallel proceedings, such as criminal and civil at the same time. There are also state subpoenas, or subpoenas issued by state licensing and regulatory boards, particularly your Board of Medical Examiners or your Board of Pharmacy. Again, all somewhat different, but all have similarities. What will the subpoena contain? First of all, it'll have the authority under which it is issued. It will identify the agency that is issuing the subpoena. It will be addressed to you, your practice, your pharmacy, your business. It will be addressed either to you or the custodian of records. Custodian of records would be the practice manager or practice owner, depending on the situation. It will require you to produce certain documents, either hard copies or digital. And it requires you basically to produce things that are within your control, custody, or possession. It will also identify the agent or the investigator working on the case. They usually will have a name and number on it, along with the prosecutor, if a prosecutor has been assigned to the case. And then it will have what's called a Schedule A or schedules. And in those schedules, the property being sought, or the documents being sought rather, are described. And so that's what a subpoena will contain. So now you have received the subpoena from a government representative, an agent, a detective, an investigator, whoever it may be. What do? They show up unannounced, unscheduled, many times during the middle of the business day, and they deliver it. Accept it. Don't try to avoid it. You can't avoid it. Accept it. Be polite. Be professional. And simply say, my attorney will get back to you. Don't engage in conversation. Don't go over it and ask them questions. Don't ask them what this is all about. Don't ask for a break. Don't ask for an extension. None of that. They would like nothing better than to engage you in conversation and learn more about your practice, your billing practices, whatever it may be, whatever their concern may be. The object here is to simply comply with the subpoena, nothing more. A subpoena may require you to produce documents, but it's not requiring you to submit to interrogation or questioning at that time. Also, there may be an offer from the person delivering the subpoena to stick around and look, if you make those records for me now, I don't have to come back. Why don't we wrap it up today? That sort of thing. Don't fall for that. All subpoenas are based on a standard of reasonableness, and there should be in the subpoena a reasonable due date. If it's not reasonable, counsel will try to negotiate an extension or go to the court to ask for an extension. But do not, there is no subpoena around which requires you to deliver records that day, or there shouldn't be. And if there is, call counsel immediately. Many times the date will be 2, 3, 4 weeks in the future, but if there's an offer to stick around, I'll take the records now. Do not accept that offer. You're going to need time to assess the records with counsel and go over those records. You don't have to make immediate delivery. Let's talk a little bit about what to do after you've received the subpoena. Well, what do? Obviously, you have to assess it. You're going to review it. Hopefully, you're going to review it with legal counsel because it's necessary. Because there are subpoenas that are defective. There are subpoenas that are onerous. There are ways in which to make it more reasonable. That is, you have to review the subpoena along with counsel to determine whether the property sought or the documents sought and the due date are reasonable or whether it's onerous. So you have to look at what's being requested. The records, are they hard copies? Are they digital? Do you possess them? Do you own them? Are they within your control and custody? Do you have access to them? That's number one. Number two is, when is the due date? Is it reasonable? Can you easily meet that? Or do you have to basically shut down the practice just to produce these documents? So those are things that, practical things, that have to be analyzed. And then there are legal matters that have to be analyzed. If the subpoena is not reasonably related to an investigation that's going on, that is, if it's just a fishing expedition, that's one particular area where legal counsel can confer with the government or oppose the government on. If it's onerous, if it's particularly onerous, that's another area. It's called a motion to quash, which can be made in court, which is basically to quash the subpoena or to limit the subpoena in its scope or due date. Now, what actually happens in reality is that legal counsel will get in touch with the government or the state agency responsible for issuing the subpoena, and we'll have discussions and we'll have negotiations. And many times the scope of the subpoena can be limited, extensions can be given on the due date, and at the same time counsel can find out what the subpoena is really all about. Are you just a witness in a case where the government feels that you have records that may help their investigation of someone else or some other entity? Or are you a target in the investigation where the government is convinced that you did something wrong and is zeroing in on you and using perhaps the power of the grand jury or the government's statutory and regulatory authority to zero in and investigate you? Or are you a sort of like a middle area, which is called a subject, where the government feels that you have records that may help their case? Perhaps the government feels that you could be a witness, but can't rule out criminal exposure or some kind of wrongdoing on your part. So it's important that counsel negotiate and engage in discussions with the government to try to figure out what this is really all about. Now, a couple things about subpoenas that you have to realize. They do not require you to create documents. Sometimes there are exceptions where it may be in your best interest to make a spreadsheet to basically summarize voluminous data or documents. But for the most part, subpoenas don't make you create a document. They just make you, or demand, that you turn over what you possess. So you're not required to make a document. You're not required to give explanations. Please remember that. Also, when you get a subpoena and you're conferring with counsel, one of the first things you'll be advised to do, and you should know it up front now, is to put a litigation hold policy in place, or non-destruction policy, whatever you want to call it, to make sure whatever the subpoena seeks is not destroyed in your place of work. That is, emails aren't deleted, or records aren't lost, or things of that nature. The last thing you want is an accusation that you tried to obstruct an investigation or purposely destroyed evidence. So those are two things that you have to be aware of. Also, what is possible is to negotiate a rolling production. That is, where you don't have to have all of the subpoenaed documents ready at one time. You can do it incrementally. Sometimes, in fact, many times, the government prefers it that way. They would rather receive it incrementally instead of one big data dump where it's going to take some time to get through it anyway. So those are things that need and can be worked out. So now it's time to produce. How do you do it? Give counsel an idea of where the records are stored, the form they are stored in, and whether they're digital, whether they're hard copies, where they're located. Sometimes it's even a good idea to have counsel come out and view them and view where they are stored, because now they have to be produced. Personally, I prefer that they be produced to me in digital form, usually a CD, and then when we get them, we analyze them. Do not produce documents to the government without having them first reviewed by legal counsel. This is not a simple thing. As I said in the beginning, I described it as a minefield, potential minefield. It seems like it's simple. Here's what the government wants. Here's what we need to produce. No, it's not that simple. Do not just produce them. Get them, gather them, put them together, give them to counsel. Counsel will then review them. Counsel may have a lot of questions for you. Basically, what counsel is looking at is whether there's anything in those documents that is privileged. It may be privileged because there are documents in there that fall under the attorney-client privilege. And although generally there is no Fifth Amendment privilege that applies to business records, there are limited exceptions to that rule, such as if a subpoena is crafted in such a way that the act of producing the documents becomes testimonial in nature and is almost akin to a verbal admission. In situations like that, which counsel is trained to pick up on, okay, there may be a legitimate privilege objection to the production of those documents. So counsel has to go through the documents and determine whether there are any documents that are privileged. If so, counsel then culls those documents out and makes a privilege log. And those documents that are going on to the government are bait stamped on the bottom, every number, 5 zeros and a 1. Okay, so it's going to be document 1 through document whatever, 450, 1400, 6000, whatever it may be. But every document, every page, electronic or hard copy, has to be bait stamped. And then a copy has to be made, because it's very, very important that you know and have record of exactly what goes to the government. So there's no dispute later on regarding your response or lack of response and integrity of the response. So everything is bait stamped, copies are made, it then goes to the government, and then the government will analyze the material. After that, you've complied with the subpoena. Remember, you can't avoid the subpoena and you have to comply with it. If not, it can be enforced through contempt of court. And you don't want that type of situation to be involved in. Normally what happens, if there is a dispute with the government, again, counsel will negotiate, and if not, you make a motion to quash. But you don't want to be on the receiving end of a motion by the government to hold you in contempt because you did not comply with the subpoena. So that's our advice when it comes to government subpoenas. I'll repeat, they are not a simple thing. They can be a minefield. There's very little you can do sometimes in terms of opposing them, but there's a lot you can do in making them reasonable and not going beyond their stated purpose. And with that in mind, Frier Levitt stands ready to assist you in any needs that you may have regarding the service of a government subpoena upon your practice, pharmacy, or business. Thank you very much.